And back again with us is criminal defense attorney Allison Triessl. This time we want to focus on the defense. Allison, welcome back. And their winning strategy that ended with 2 charges against Rittenhouse dropped and an acquittal on the remaining 5 charges. We spoke with you last hour about the prosecution and whether it underperformed, whether they underperformed. Do you think the defense outperformed?
They did, and here's why. It was a very, very risky proposition to put their client on the stand, but they knew to effectively argue that this was a self-defense case, the jury had to hear from him. And so he was very well prepared, and he stuck to his script. No matter what the prosecution asked him in cross, the narrative was always the same. It was, I did nothing wrong. I had to defend myself. If I didn't, they would have killed me. So they spent, it was clear that his attorneys had really thoroughly prepped him and that he was prepared for any question that the prosecutor was going to ask. Now, some people have questioned the emotional outburst that he had, whether it was real or whether it wasn't. But again, this jury verdict was it. They felt very strongly that he was telling the truth, and that he never really apologized. He said, I had to do this. And so and I think that's what won them the case, was his actual testimony.
And his attorney said, we had no choice. We had to put him on the stand in Wisconsin in order to save him. The country is obviously so divided on this case. It seems some see this as a vigilante looking for trouble. He got off after killing 2 people because of his white privilege. Others see him as a hero who stepped up to protect property. He had every right to defend himself. What kind of message does this verdict send to the country?
All right, well, this is very important. So just from a legal standpoint, this did not set any legal precedent, right? Okay, because if there would have been a conviction and he could have appealed, that case, that appellate case would have been case law in Wisconsin. But because he was acquitted, the prosecution cannot appeal this sentence. And so this is not case law. But in terms of a bigger message, is this a Second Amendment case that says that if you can patrol the streets and you can be armed, and it doesn't even have to be your property that you are going there to protect, and if there is a danger to you, either real, imaginary, or somewhere in the middle, you can fire back? Is that the message? I'm not really sure, because the gun laws in Wisconsin are quite different than other states like California or New York, where they have much stricter gun laws. But I think that's the discussion. That's the flashpoint for our country.
Explain why it didn't work to argue he put himself in danger. He created this dangerous circumstance. He went there with a gun he wasn't allowed to have. He crossed state lines. He was out past curfew, and he was pointing a semi-automatic weapon at people. Explain why that didn't work.
And what's interesting is that's what the prosecution hammered home. And the prosecution was very much relying on the fact that the judge allowed that instruction that said, if you bring the danger, if you incite this, you cannot hide behind the self-defense argument. But what happened here is their own witnesses, and we talked about this before, there were 2 prosecution witnesses that testified, and they testified for the defense, essentially. And one of them said, I was very close by, and Rosenbaum lunged at Rittenhouse, and he tried to grab the barrel of his gun. And then their other victim, who was shot, not killed, testified that he, in fact, pointed his own gun toward Rittenhouse. Didn't say at him, but said toward him. Those 2 things hurt the prosecution's case. And so this jury said maybe he shouldn't have come there, but his life was in danger, and he had a right to defend himself and kill the people because they would have killed him.
A lot of people are talking about civil suits, right? Like now you're walking, now you're going to get sued civilly. But do you see any prospect of that? What does he have? He's an 18-year-old kid.
Well, that's the thing, right? They're not going to really get any monetary damages. Plus, I don't know how many civil attorneys are going to take this case because although it's a lower standard, he was acquitted. So if they're working on a contingency and there's not that much money there, they may see it as kind of an ethical or civil obligation.
All right. Allison Triessl, thank you so much for joining us with your expertise once again.
Thanks for watching. Click the red subscribe button below so you can get more of NewsNation's fact-driven, unbiased coverage.